Welcome, welcome, welcome to the Challa Law Weekly Wednesday webinar. And today we're going to talk about processing times, delays, what's going on, some good news, maybe some not so good news. Let's give people a few minutes to join and we will get started talking about everything from NVC to their backlogs to the Department of State. What's the USCIS doing with the I-485s? It depends on where you live. And then, of course, the proposed regulations on premium processing. So, like I said, some good news and maybe not so good news. So I want to thank everyone for joining. Today is, if I hadn't said it before, March 30th, 2022. And I want to say hello to all the people on YouTube Live. Thank you for joining us. And for all the people that have been attending our webinar every week, thank you for attending. And for those who are new, welcome. So before we start, can I see a raise of hands for those people who it's their first time on our webinar? So it seems like today we've got at least from, and I've never tried seeing how the YouTube streaming looks. So, but at least from our folks local, it appears as if most of the people are weekly diehard fans. So we're appreciative that you join in, and we try to make the content as relevant as we possibly can, so that you can enjoy the webinar. But I have never been on a YouTube Live, so I don't even know how that looks. Let me see if I Google Challa Law, will it come up? I just want to know how easy it is for, it's so wonderful that we get so many people from YouTube Live that I don't know how to get to it, but that is my shortcoming. I'm very challenged with these things. That's why I'm so glad I've got a whole host of other people who are much better at this than I am. Because I figure if you look up Challa Law, it should, I would think, pop up. But no. In any event, I was hoping that I could talk to the YouTube people directly this week. Maybe next week, I'll try to figure this out. But let's get to it. So let's start off with the good news. On March 29th, USCIS issued information on proposed expansion of premium processing. It was part of their implementation of the Emergency Stopgap U.S. Stabilization Act. And I still have to read through all of it. As you can see, it's pretty large. But so the effective date of this new rule will be 60 days after the date of publication in the Federal Register. So how does it work? When an agency issues proposed regulations, they have to go through a process which is called notice and comment. So notice and comment is where they publish it like they have, and they give the public a chance to kind of chime in and issue some notice and comment about the regulation. And then they publish it. Then they send it to the OMB, and then they finally publish the final regs in the Federal Register. So it's going to be 60 days after the date of publication in the Federal Register is going to be the effective date. And does it affect everybody? No, but it really includes, I see Abir is here. So Abir will be happy to learn about this, that the premium processing expands the I-140s that are eligible for premium processing, multinational managers and executives, national interest waivers who could not avail themselves of premium processing before can do that now. It'll take 45 days, so it's not the 15-day, but hey, when you're looking at 2 years and some waiting, 45 days is not bad. And the fee for that is $2,500 is the proposed fee. The biggest issue has been for I-539. So I-539 is filed for anyone who is changing their status from one non-immigrant category to another, except if you're changing it to like an H or an L, one that requires, or an E that requires an I-129. But for the most part, if you were changing or extending within your status for a broad variety, like your dependents and so forth, there was no premium processing unless they filed with the primary. So now the I-539 requesting a change of status to F1, F2, J1, J2, M1, M2, or change of extension of stay in E1, E2, E3, H4, L2, O3, P4, R2 will be eligible. The time frame is 30 days, and the fee for that is $1,750. Not bad, not bad. And for the I-765, yay! Can we hear a big yay for the I-765? Because that is amazing. I mean, that's what we've been waiting for with the incredible delays. Premium processing is going to be $1,500, and the time frame is going to be 30 days. And that's a big relief for all those people that have been just, stuck in this, in these classifications where you really didn't have a way to avail yourself except asking for congressional intervention, which can be slow and when it's forthcoming. So now some of the other news. Now we keep hearing from clients that, hey, how come my petition hasn't moved? How come, I got it approved so long ago? We haven't heard anything. It's not something we can do. We cannot control processing time for certain types of processes, except ask for an expedite through a government agency. If there's no other process in place, if there's no compelling interest, and they're getting tons of those. So we can try that, but it may or may not work. So we have to understand what the landscape is so that we can at least brace ourselves for what's ahead. So let's talk a little bit about the folks overseas. The National Visa Center backlog. So remember, if you've got an immigrant petition and it's filed in the United States, once it's approved, it has to then go to the National Visa Center. The National Visa Center basically acts as the liaison between the USCIS and the Department of State, who ultimately will issue the immigrant visa abroad. And it has to go through that process. So the National Visa Center, when USCIS approves a petition, in the good years, it used to take 6 weeks. It probably takes double, if not even longer. If you estimate that the processing time for everything is increased threefold, so 6 weeks, 18 weeks, it could be anywhere from that time frame, 8 to 18 weeks. So it's taking a long time. So the National Visa Center in March issued an update, and they said the COVID pandemic has dramatically affected Department of State ability to process immigrant visa applications. U.S. embassies and consulates are working to resume routine visa services on a location-by-location basis as expeditiously possible in a safe manner. The particular constraints on local conditions and restrictions, but include local and national lockdowns, travel restrictions, and host country quarantine regulations, and measures taken by our own embassies and consulates to contain the spread of COVID-19. So President Biden issued an order, and the title of the order was Restoring Faith in Our Legal Immigration System. And through that, they wanted to make sure that the agencies had some transparency about what is going on in terms of the backlog. So as of March, the number of IV applicants whose cases were documentary, complete documents were complete and ready for interview as of February 28th were 469,017. The number of documents complete scheduled for March interview of those that were complete that are scheduled for March interview are 32,000, just 32,000. So just think about that for a minute. 469,000 have been complete by the NVC, but only 32,000 and a handful are scheduled for a March interview. So the number that are currently still pending is 436,000. That's a lot. That is a lot. So, of that, you have to then look at local country restrictions. And I thought I pulled up what it was for India, because I know a lot of you are wondering what the processing time is in India. So fiscal year 2021, New Delhi processed 7,338 immigrant petitions and 48,060 non-immigrant petitions in total. Well, the immigrant petitions are only processed at New Delhi. You have Chennai processing 69,000, Hyderabad 34,000 and something, and Kolkata 16,000. Sorry, Mumbai was 7,338 and 48,000 non-immigrant petitions, with New Delhi processing 433 immigrant petitions and 88,198 non-immigrant petitions. And so in February of this year, New Delhi processed for parents of US citizens, that's not, IR. They just did SB1, just 34 of those, and a handful of others. So not a lot of immigrant petitions out of New Delhi. Let's take a look at Mumbai. Mumbai has processed a number of crewmen, but 3 F1s, 3 F2Bs, 26 F3s, 429 F4s, immediate relatives, they filed 668, IR2, 68, and IR5, 413. So that is it seems like if you look at relative to the numbers for 2021, that there seems to be an uptick. Let's just hope the new variant does not reduce those times. Now let's take a look at what's happening with the 485s in the US. And I was looking through the report, and it varies from, where you're processing. I think Albuquerque, New Mexico has 2 months to 7 months where they process the I-45s. This is at the local office. You have Brooklyn, New York, 10 to 27 months. Charleston, South Carolina, 7, and that's it's a large jurisdiction. 7.5 months to 13 months. But it's interesting to me that Charlotte, North Carolina, which I would think would have a much larger pool, is 8.5 months to 15 months. Well, let's take a look at Raleigh, because Raleigh, we've got the RTP, and it's probably near Richmond. Oh, there's Norfolk. And Raleigh, North Carolina, 10 months to 17.5 months. And that seems to be, and for those who are in our jurisdiction of Norfolk, Virginia, it's 12.5 months to 36 months. So both on the consulate level and on the local office level, you can see that there's tremendous amount of delays. So as they're working through what was almost a trickle in processing during the crux of COVID, trying to catch up a little bit last year with some fluctuations in their workload every time a new variant came up, not knowing what they needed to do. I think they're just trying to work through that 2 years of backlog, which is tremendous. And then still not having enough personnel to process the casework. We did talk about how Congress has funded at least DHS to increase their processing. And part of that funding information is in the expansion of premium processing, although one hopes that when you're paying $2,500, that that should cover the ability of the service to premium process your petition. One of the other things that they really need to look at is it's not just adding people or, throwing money at the problem, but do some assessment of whether some of their services could be done away with. And I think it was the Brookings Institute that actually broke down, and I'll see if I can find that and we'll post it, how long it takes to process a 485. And they've expanded that form during the Trump administration, and how those additional pages, which really don't add to anything really for the for how a beneficiary meets the qualifications of the 485. So it doesn't add anything, it doesn't enhance anything, but it increases processing time. They talked about how if, and I can understand the biometrics part, although while they're waiting for the card, if they would let them, and they do in some categories, people go ahead and start using their receipt notice for the I-45 for work authorization and travel, that would take out a lot of backlog in the time. And of course, the addition of the I-45J. So I think there are ways in which they can, improve their processes internally and do some BPR, business process reengineering, to find efficiencies in some of the things that they are doing internally. So that is our update for processing times. We had some good news. We had some not so good news. And we will be happy to answer any questions. I'm going to ask I don't know if our moderator, Shaker Challa, is ready to moderate this Q&A. If you have any questions, we ask that you place the questions in the Q&A box and not in the chat. And we'll use the chat for information that we're going to send to you or any clarification that we need. So Shaker Challa, if he's not going to...
Not on right now, so I'll go ahead and start reading you some questions.
Absolutely.
All right, from Daryl Mulder.
And for those of you who don't know, please say hello to Lainey. Lainey is instrumental in putting all of this on, so she's the face behind the Challa Law Group, appropriately Globe. So go ahead, Lainey.
All right. Daryl Mulder says, I've had an outstanding B1 application since October 2020. I went for biometrics in January, but have heard nothing since. How long is it likely going to take now?
Wow. Now, October of 2020, I hope, because you would have, remember when you're asking for an extension, there are two things. Number one is, yes, it preserves your status while it's pending, but only until the end date of the extension request. So if you ask for 6 months, yes, you can stay here up to that 6 months, but you either have to file a new extension, bridge those extensions, or you would have had to depart the United States before the extension expired. So that's not answering your question, but I would be more concerned about that. So email us at info@challalaw.com if you need any clarification on that.
He clarified and said that he is on an E3 currently.
Oh, you're on an E3. And is your E3 valid?
You can drop that in the chat, Daryl. We'll wait on him to get back to us if his E3 is valid. Oh, he said yes. His
Okay,
E3
good.
is valid.
Good. So as long as your E3 is valid, then you are in good shape. And so it is taking a long time. It is just the nature of I-539s. So you may want to at least, because I would imagine that, you're, so as long as you're E3, I would imagine that your validity period that you had outlined is no longer valid. So you would probably want to make sure that you update them with a new validity date. So that's what I would do. I would make sure that you updated your validity date so it included, the additional period you asked for. Because I would imagine in 2020 you didn't ask for a date beyond 2022.
He further clarified and said, I'm looking to go back to Australia in early May. That should break my application.
Correct. And as long as you've been maintaining a valid E2 status, then you're fine.
All right, next question is from YouTube from Sweet Seller. With so many cases moving from SRC and LIN to NBC, would NBC slow down the processing for the applicants who are currently under process?
Right. So here is how that's working out. NBC it's already over. I mean, it's already overwhelmed, as you can see by the numbers. So you're right that as we see the USCIS improving their processing times, unless we see the same kind of improvements in the NVC, we will see the backlog increase more.
Next question, also from Sweet Seller. Is it possible for the primary and dependent 485 applications to go to FO on different days? How long does FO take to adjudicate the case? FO meaning field office, I'm assuming.
Usually they'll try to get, if you're a primary and dependent, they try to get those folks, they try to have those both at the same time. It makes sense to have them both at the same time. Because really, although the adjustment questions are more about the individual, their background, you know, have they done anything that from the time they filed till now that would hinder their ability to adjust status in the US, their health records. They also sometimes will ask questions about employment. You want to make sure it's consistent. If you have it together, they don't expect the beneficiary to answer. They will have the primary answer. I know some field offices that have sometimes gone rogue and will try to find a way to, you know, not provide the benefit. And I'll give you an example. We had a client come to our office and she was denied her citizenship application twice, even though she had answered all the questions correctly on the civics exam, passed the English exam beautifully. Where they tried to find fault with her was the first time she was denied is when the field officer was asking her what her name was. She said it so fast that she goes, "I'm sorry, I didn't understand what you said. I didn't get what you said." She goes, "Oh, you don't understand me," even though she had just finished passing the English exam and answered all the questions for the civics exam. She goes, "I'm going to deny your citizenship." And she cited a particular regulation as to the basis. Second time this young woman goes in, she answers the civics exam questions. She answers the English exam, does beautifully, answers her name this time because now she knows it's coming. And then the woman proceeds to ask her Section 12 questions. Section 12 is, have you committed trafficking? Do you plan to go against the US government? Have you ever been with a Nazi group? You know, all those questions which would make you, which would bar you from admission to the US. And there was nothing to suggest in the record that she suspected this woman of anything. But when she asked her a question about prostitution, the woman told her what she thought, but she did not want to, because she's very conservative, say it in a very explicit manner. And so the woman said, "No, prostitution is when you receive money for sex." And that was something the woman didn't want to say. So she denied her again. Third time I went with her. First of all, we had to file, it was a team effort, a motion to appeal this so she could apply again. So she didn't have to apply a new citizenship application with all those fees. And because the appeal was successful, she was granted a new naturalization interview. The woman goes to the interview and I went with her. And first thing I stated was, I hope she doesn't have to take and it was the same adjudicator. She pretended it was somebody else, but this woman recognized her. So I said, she's already passed the civics exam and English exam twice. I don't think she needs to take those exams again. And she said, yes, but I think she didn't. There was a couple of other questions she didn't get, and that's why she was denied. I said, they were Section 12 questions, and the denial stated that she was denied because she didn't pass, because that's the only reason they can deny you is if you don't pass the civics and I said, and according to the USCIS policy manual, the adjudicator can only deny it in 4 instances. And Section 12 questions are not in any of the 4 instances. And she goes, well, let's just go ask those questions again, and we'll skip the civics and English exam. She asked her those questions. She granted her naturalization. And she even said, oh, your picture's so beautiful, it'll look great on the naturalization certificate. But it made me so mad that this poor woman, she was shaking, literally was harassed 2 times. In fact, in the last interview, she said a number of other officers also came in and they were all laughing at her for not being able to answer the prostitution question the way they wanted her to. So, but I was happy she prevailed. And for field offices, so the reason why I'm telling you this story is you never know what's going to happen. It is better that the primary and dependent go together. Next question.
Also about field offices from Sweet Seller, a simple question: can a case get moved to a number of different field offices before getting approved?
Usually not unless there is a change in your address. It usually will go to that field office. In some instances, very few, if the field office is incredibly overwhelmed, and they usually will announce it, that they will be forwarding some petitions to another field office, but that's happened very rarely.
Our next question is Ramu Badam. Can you please talk about when an H-1B dependent can be eligible for Dropbox after his 14th birthday if they drop with H-1B applications? Please note this is not the first time.
What was it again? Drop before their...
It's about after their 14th birthday.
Yeah, so there's Dropbox for primary and beneficiaries is eligible as long as the visa had expired within the last 2 years, and you received the initial visa and for the same classification in that same country. So the fact that they're 14 does not impact their ability to, it could be the spouse and children under the ages of 21. There you go, Dropbox eligibility. It is posted for you to take a look at.
Next question is back on YouTube. Sujit Kumar says, if my AOS, AP, and EAD application is pending, what are my options for travel in urgency?
So his AP, now I'm going to assume that you're probably, are you currently here on an H or an L? And if you are, when did your visa expire? Please answer that in the chat.
We're waiting for Sujit to respond on YouTube. We can go to our next question from an anonymous attendee. Do we need any affidavit if first name and birth certificate has space in it, but passport and visa docs do not have a space on them?
I would, just for clarification. If you can write your name in the chat. Sagar, you're welcome.
Anonymous attendee, if you want to just message the hosts and panelists with your name so Attorney Challa can look at it. They had some follow-up questions. Do we need an affidavit of birth certificate registered in same born year and issued in a later year?
No, if the birth certificate is issued within a year, then you can probably, and I would just add some affidavits just to as additional documents to support it. It is only when I hear of people getting a birth certificate 15 years later, 20 years later, 30 years later, that the birth certificate, USCIS said it wasn't issued contemporaneously with the birth. It doesn't mean that it has to be issued at the same time. You know, especially registering a birth in some jurisdictions, there may be processing delays. Hello, Mr. Challa.
Hello, sorry I was stuck in an earlier meeting, but where are we? Are we done or are we still?
I'll go ahead and finish this last question and then
okay.
I'll let you know where we're at. The last question of the same question about affidavits is, can we send mark sheets and transfer certificate, which has birth date on it, as a secondary documents for birth certificate?
Well, you'd have to, we have used like 10th standard docs, and I just don't send in 10th standard document because 10th grade to us in the United States means nothing. but these are board exams, right? So I would submit it with some information about how, banks in India use 10th standard docs as documentation. If you have a, what is the Indian ID? Aadhaar card. If you've got an Aadhaar card, submit that and then show that, that's a form of ID that's used in the United States. So you can use all these other things, but you should have something to back it up because they're not going to understand why the 10th grade transcripts are so significant.
All right, Lainey, you want to continue or you want me to take it up?
I'll start putting the questions for you. I just messaged you the first one you should start with.
Okay, there's one on the Q&A. I'll take that first. It's from Srini Rao. How dependents I-145 will process along with primary or individual?
They usually try to process them together, although there have been times where I've heard where the beneficiary has been approved, but the primary hasn't. And that is probably some clerical error, but the norm is they're processed together.
All right, this next set of questions coming from, I guess from YouTube. Anonymous attendee, can you file a new I-485 in EB2 based on approved I-140 if derivative H4 spouse has used the AOS EAD and primary spouse is on H1? Note that EB3 downgrade I-140 is pending.
Yeah, so I've said this before, dependents can use whatever they want because their status is not conditioned on their employment. Primaries, you're the H-1B visa holder. As long as you have maintained status, they maintain status, whether they use their EAD H-4, whether they use their EAD I-45, doesn't matter.
Okay, the next one is from YouTube, Hunter. Are there any EB3 visa numbers available? I hardly see anyone getting approvals in that category. Do you recommend interfile to EB2 even if priority date is in June 2011?
What I would do is next week we should have better numbers, Hunter. So let's take a look at that. I'll have the processing times between EB2 and EB3 and have what the backlog is. And we can cross-check that with what the visa bulletin we suspect will look like and try to come up with a solution. And I think your question will help a lot of people with that are probably in the same boat.
All right, next question from Abir Singhal. Mr. Singhal, how are you? So, hi, Lakshmi. Good news that EB1C is up for premium this year, and I would like to apply the moment it is available. Question: since we have done biometrics with medical review and been issued EADs with parole, does that mean we have completed background check and medical check for adjustment to status? In that case, has USCIS waived the adjustment of status interview? Basically, if we get I-140 premium and is not rejected, what are we looking at for adjustment of status and green card printing?
Right. So yes, that's a great question, Abir. So these are like parallel pathways, right? You've got your I-140 and then you've got your I-485. So a lot of the preliminary things have already occurred on your I-485. So it's not if your I-140 gets approved, it's when your I-140 gets approved. Then if they, especially with the type of petition that you have, it's a very high likelihood that they will waive the interview.
All right. Next question from YouTube, Sri Reddy. Can you please explain significance of barcode at the bottom of the USCIS form?
Yeah, they instituted that sometime back. From what I understand, it's to streamline processing and, like a barcode is used for anything, location of files. I have not found that there have been times where they lose the G28, and we've had to tell them like several times that we submitted a G28 on file. So I don't know how effective that is, but that's what they claimed the primary purpose of that was.
Next one from YouTube, another anonymous attendee. If primary is maintaining H1 and derivative uses AOS EAD, is she giving up H4 status while H4 EAD extensions are pending? Once H4 extension is approved, does the spouse have to leave the country and re-enter using H4 to restore the non-immigrant status and move to H4 EAD?
No, as I said earlier, remember H4s are dependent. So as long as the H1B has maintained valid status, the H4 maintains a valid status, and there is no condition because they are not an employment-based category. They're a derivative category, dependent category, if you will. There is no condition on whether they work on their H4 or their I-45 EAD.
The next one is from Krish. Currently, I'm working with company B. I have an approved I-140 with company A. As my dates are current, I'm planning to move to company A. After company A files my 485, do I need to stay with company A until 485 is approved, or can I move before approval? Also, while my 485 is pending status and dates retrogress, will it impact my I-485 process?
Well, that's a lot. So here is anytime you file a new I-140, the AC-21 clock restarts. You have to have the present intent to work for your employer after your green card is approved. The present intent. That intent can change. And the mechanism that allows you to change your mind is AC-21. After the I-140 is approved, and if it's already been approved, you don't have to worry about that. But the I-45 is pending for 180 days. Then you will have to, at that point, if you want, you can change employers to same or similar employment.
Okay. Next one from YouTube. Can we expect the final action date for EB2 move to September 2014 by October this year?
Join me next week. Like I said, I don't think we'll have the first quarter numbers by then. But until we have, we'll have at least some, because I got to answer Hunter's question, whether he should interfile or not. So we are going to go into a little bit of how much they've processed, and we're seeing that the posts are not really processing a lot of immigrant petitions, but I'm just getting it out of India. I've got to look at China, but India and China are where the vast number of immigrant applications come from. So we'll take a look at that, and I can give you some sense of what the movement should be.
All right, next one. I have filed I-485 in October 2020, but did not include birth certificate, included only affidavits. Did you see any cases earlier, I-485 approved without birth certificates?
So the regulations, so the Foreign Affairs Manual governs what kind of documents you should submit for proof of birth. They have primary documents, and then they have secondary documents. The recommended secondary documents, and you can submit others, is a certificate of unavailability from your registrar, panchayat, or any local record-keeping office, and 2 affidavits of birth. Now, where the local panchayat won't issue, or it's hard to get, the local registrar to issue the certificate of unavailability, you're also permitted to submit secondary documents. other secondary evidence. So I would submit your 10th standard board transcripts and records with your name, date of birth, parents' information. If you've got an Aadhaar card, I would submit a copy of that. And do that with evidence as to why these documents are significant. It's not enough that you just submit them. They won't know what they are. But if you show that actually in your country, and that goes for anyone in their home country, they could be different documents. You want to show the significance of those secondary documents to make sure that the evidence that you submitted is probative.
All right, next one. I'm currently working on OPT EAD and it's expiring next month. I have not applied for H1B since I'm planning to work on H4 EAD as my spouse has approved I-140. Please let me know how to switch from the OPT EAD to H4 EAD status.
The quickest way is to pop out of the country, and you can check to see whether you can go to Mexico and get an H4 and then re-enter. If you already have an H4 visa in your passport, but you're currently on an F1, a lot of people think that that H4, as long as it's valid, you can go out of the country, re-enter on the H4 visa. So you can do one of those two things. Filing a change of status in the US until premium processing is eligible for H4s. Doesn't make it, it'll take too long.
Next one is from Iram Masood. This is Sijal Aziz. Regarding the L1A visas, are not-for-profits eligible to apply for L1A for their employees?
Yes, as long as you meet the qualifications for the qualifications of the regulations. They make no distinction between the type of evidence not-for-profits submit is a little different than for-profit entities. But we've done a ton for nonprofits, and there is no problem in their ability to file for you.
Our next question from AA. Hi, I'm currently working with employer A and am having approved I-140 with employer B. Can I work on concurrent H1 with B to get my 485 filed while it impacts concurrent H1 with B filed? Will it impact anything in future?
So he's working for employer A. He's got an approved I-140 with employer B.
Yeah, and having approved I-1 for the employer B, yeah. Can I work on concurrent H1 with B to get my I-140 filed? Will it impact any future?
To get your I-140 filed, I thought you had an I-140 filed with employer B.
Having approved I-140 with B, yeah.
Do you want to do a downgrade or an upgrade?
Okay, I'll take the next question while we wait, because Anil Kumar, I'm currently working on Opt Ead and it's expiring and I have not applied. This is again a repeat question. I don't like when people are repeating questions and it's confusing. I'm sorry to say. Gopalakrishna Arthanari, is it okay to send medical papers that were signed by doctor on June 2021, 485 filed in October 2020 to USCIS now? It is not going to have COVID details though.
Yeah, so when was it issued? When were the medicals issued?
On June 2021. I-485 was filed in October 2020.
Yes, because I think we have a memo on this, Lainey, where the USCIS extended, it used to be you'd have to submit it within, I think it was 60 or 90 days. Now I think you could submit it within 1 year. But we'll post the article that we have on that. And it doesn't have to have the COVID information.
Don't know what It says refer to an earlier question, but I don't know the earlier question. But it says, I think it's something to do with how the name, the first name and last is on the passport and the birth certificate. There is no space. So Bharat Kumar, Bharat and Kumar. First
Oh,
name in the
okay.
passport and visa, Bharat Kumar together is in the passport, and Bharat Kumar separate is in the birth certificate. I think he's trying to ask, will it impact?
Yeah, you can just say that it's, and I would get just affidavits saying whatever it is that you're typically known as. I would imagine, because there's sometimes that are names that are attached together that become disjoined in the United States when you're filling it out because there's a middle name. So you can just say that you're known as both. You can even file an affidavit yourself, and show how, that although you're Bharat Kumar, that's the full name as it's listed in the birth certificate. You've just gone, you can, for purposes of how you filled out your immigration forms, you made the Kumar a middle name.
This question is from AA. Any update from Texas processing I-485 as my AOS transferred from NBC to Texas last year with priority date EB3 May 2010? Can we expect this fiscal year?
When did they say it went to Texas?
My AOS transferred from NBC to last year with priority date EB3 May 2010. And when it went, I don't think they specify anything.
So it's with the Texas Service Center, or it's gone to the local office?
It says from Texas, transfer from NBC to Texas.
Oh, okay. Yeah. Texas is taking a really long time. I mean, they're quoting, I think last time we checked, 3 years with their backlog. So it's hard to know how long it'll take. But next week, because of Hunter, we're going to look at some of those processing times at the service centers. So join us next week.
Okay, that gentleman or lady, whoever was asking about working with company A, having approved I-140 with employer B, can I work on concurrent H1 with B to get my I-485 filed? They added, my PD will be current in next month, and in parentheses, no need downgrade or upgrade.
Okay, good. So you don't have to, since your I-140 is already filed, remember your green card, your adjustment is for prospective employment, not for current employment. You have to have the present intent to work for your employer after your green card is approved. So you really don't need to do a concurrent you don't need to do a concurrent H1. You can, that'll support your petition better, but the hours have to be, if you're working 40 hours for someone, can't work 40 hours for somebody else. So if you're going to put down 20 hours and you can justify when you'd be working for that employer, clearly that'll show that you have the present intent to work for the employer in a future time frame. But you don't need to do that in order for the petition to be approvable.
The next one is, hello, having a valid H-1B visa after getting 485 EAD and parole card, shall I go outside of US and get H-1B stamping with Dropbox?
Sure. And I guess he was asking, can he come back? If there's some reason the Dropbox doesn't work, can he come back on his AP? Yes, you can come back on your AP. And that will not, as long as you don't work for an employer other than your H-1B employer on an EAD, you can enter on an H-1B visa or you can enter on an AP.
That's about all. And I see many of you all there say anonymous attendee. and that's perfectly okay. But if you know your name, you can easily personalize the discussion. You can address with your name. And sometimes we see anonymous attendee in the Q&A, and we see in the chat your name, the same question. So I think I'll leave it to you, but I just wanted to share that feeling. You can always personalize when you're answering a question. Your attorney can address with your name.
Right. And I
All
want
right,
to remind,
that's about all.
well, I wanted to remind folks a couple of things that if you've enjoyed this, if you found it helpful, please, tell your friends about our Challa weekly webinars. I'm trying to pull up the linked presentation so I can share that. If you've got your phone, all you need to do is put your phone up and to the QR code. And Lainey, if you're looking at it on your iPhone, you can actually take a screenshot of the QR code, but she will send you a link in that regard. And then you see, if you have not joined our Challa Law Group Telegram group, that it's a great community that are people who are like you, that are going through immigration and provide a lot of support for each other. And we're there. So, we would love for you to join that. Again, take your phone up to get the link, share that with your friends. Let's grow the community. The more we grow the community, the more we'll be able to really be a resource for each other.
I got
Then
one last
finally-
question to ask.
Mhm.
There's one question that came up. Of course, one is thank you for your time and helping the community. The Telegram group is shared with my friends. Somebody said that. Thank you.
Thank you.
One last question from somebody, I don't know. Just a quick question, ma'am. Downgraded as an amendment and got EAD and AP. Do you see any downside of using EAD and AP until I get 485 interview in EB3 category?
Well, I always suggest you can use it, but preserve your H-1B. The reason is it's always good to have a safety net. I believe in that. Maybe I'm a little conservative in that approach. So you can use your AP and EAD to work for your H-1B employer. But if you're going to change employers, amend your H-1B to reflect the new employment so that you've got that as a safety net. And
All right.
for those who, I'm going to be doing a debrief on the new proposed regulations on our YouTube channel. If you're not subscribed, you won't know when we got updates on the YouTube channel. So again, take a picture, get a link, share it with your friends, do a screenshot on your phone. I did that the other day and it worked. So that you can kind of, or use the link Lainey provided. So you can get updates when we upload new content on our YouTube channel.
Yeah, I want to just make one quick announcement about the EB5, just to remind folks, if anybody interested in EB5, the new regulation has come. So if you'd like to know more about it, or the opportunities for investing for a green card through EB5, send me an email in info@challa.com. We'll be glad to let you know the details.
Thank you, Shaker.
Yeah, the good thing this time around is you can invest, file the I-485 form I-26. You don't have to wait for the approval. You can file the 485 at the same time if you're on a valid visa in US. That's the greatest thing that they have done.
Oh, absolutely. So especially if you just started your permanent residence process, and there's many ways you can come up with the resources for the funding. You can have multiple people help you either through gift, through loan. There are different ways in which you don't have to have all the money yourself. There are different ways in which you can use various resources, various mechanisms to have the money for the EB-5 investment. And so that way, at least you're reducing that long 12-year line that most Indians and Chinese nationals have to go through. So with that, Shaker.
Yeah, I just want to say, Anil, send that question to info@Challa Law, and I'll send an answer for that. Thank you.
So I want to thank our team for all their help and putting this together. Shaker, I want to thank you for moderating, Lainey for stepping in and helping coordinate all of this. We will see you next week, where we will dive deep into Hunter's question. Should I or should I not interfile? What's going on with the visa bulletin? So join us. And if your friends are trying to deal with that same question, then share our link with them so they can join us as well. Till then, have a safe week and look forward to seeing you next Wednesday, 12 p.m. Eastern Standard Time.